Hi, a very warm welcome to everyone tuning in to our intellectual property webinar. I'm Marcus from JTC, and I'll be your host for today. To share this presentation will be recorded. Before we begin proper, I would like to go through some housekeeping rules. So first off, everyone by default is muted. And if you have any questions for our panelists, we have a Q&A segment at the end of the presentation. So if you could, please note down your questions and share them with us in our Q&A chat box once we begin the Q&A. So with this in mind, let us begin. Starting up your intellectual property strategy. In a world where intangible assets are seen as the lifeblood of many startups and global companies alike, shouldn't you accord the same level of importance and attention to your intangibles as well? To help you get started on your intangibles journey, we are here to discuss, glean insights, and learn best practices from our speakers. We have three distinguished IP professionals with us today, and prior to their presentations, I'll be doing a quick introduction. So to kickstart this webinar, we have with us Khoo from IPOS International. Eric is the head of business development at IPOS International, a wholly owned subsidiary of the Intellectual Property Office of Singapore. Eric oversees the expansion of IPOS International into key local and global markets, providing advisory and solutions to private enterprises and governments in IP creation, commercialization, and management. So without further ado, I'll now be passing the time on to Eric. Eric, please.
Thank you, Marcus, for the very kind introduction. So let me just share my screen first. Okay, just wanted to check if you guys are able to see my slides.
Yes, looks good.
Okay, fantastic. Right, so very good morning, everyone. And thank you to JTC Launchpad for inviting IPOS International to share with you on this topic of the importance of intangible assets and intellectual property to startups. So I'm Eric, and I head the business development unit over at IPOS International. And I'm happy to offer a couple of thoughts here today on how is it that you as a company or startup, right, can protect and manage your intangible assets and intellectual property as strategic business assets. Now, I know intangible assets and intellectual property are quite a mouthful, so I'm going to use the acronyms IA and IP to represent them moving forward in the slides ahead. Okay. Right. So, of course, as with any mandatory slides, we need to just show and tell you who actually IPOS and IPOS International are, just for those of you who are not familiar with us. Right. So for IPOS, we are actually a government agency which is under the Ministry of Law. So it is the statutory board for IP policy and infrastructure. It is also the registry for you to actually register your trademarks, patents, designs, and other IP rights as well. And as for IPOS International, which is where I'm from, we are a wholly owned subsidiary of IPOS. So we can look at IPOS International as a enterprise and engagement arm of IPOS. And we primarily support businesses and professionals in a couple of different ways. Number one is actually advisory to help with companies drive your business growth using IA. We also provide industry and technology insights through the analysis of patent databases. And finally, we provide anything from half a day to a 2-year master program in terms of training to help you to develop your IP skills and capabilities in enterprises. All right, so that's the quick spiel on who IPOS and IPOS International are. So I'm going to cover this couple of topics over here for today. So, just a very quick understanding and overview on what are intangible assets, what are the kinds of IA you can actually find in business, how do you go about managing it, some practical considerations, and finally, I'll end with a couple of resources that are useful for enterprises. All right, so on the very first point, what exactly are intangible assets? So in order to highlight this point, right, I thought this diagram over here to help you to differentiate between tangible and intangible assets is going to be a useful one. So as the name or the term themselves actually suggest, right? So tangible assets are those things which you can kind of like touch, see, and feel. So these are more physical in nature, whereas intangible assets are not so tangible. That means you can't really touch, see, or feel them. So examples of tangible assets will be, like your cash, land, machinery, equipment, furniture, and so on. And intangible assets will be your patents, trademarks, basically your intellectual property. It can also expand to areas such as your internet domain names, your customer list, your know-how, goodwill that you've built up over the year, employee contracts, and so on and so forth. So because of the nature of tangible and intangible assets, as we said, tangible are physical in nature, which is why they tend to be able to be destroyed by forces of nature. So if you have a flood, if you have a fire, or if the factory gets struck by lightning, these tangible assets can get destroyed. Whereas intangible assets are not so easily destroyed or cannot really be destroyed by forces of nature. So that's another distinguishing factor as well. And I think one of the most important distinguishing factor between tangible and intangible assets is that for intangible assets, you can actually have multiple parties using it at the same time. So what do I mean by that? So going back to tangible assets, so let's take the example of a piece of land. You have a piece of land. What you can build on it is maybe a factory or a retail shopping mall, or maybe even a mixed use. So you have a retail mall together with shopping, together with office as well. But the thing is that that piece of land, once you have actually built up this building over there, that's pretty much the usage already. Whereas for intangible assets, let's say if you have a patent you can slice and dice it in many ways. So to one party, you can say, I allow you to use this patent in this particular way. To another party, you can actually use it in a different way as well. So you can actually structure a lot of different deals or different licensing arrangements with your intangible assets. So in a sense, intangible assets can be cut up and the use can be multiple or multifold in a sense. So that's a very powerful concept of intangible assets, which is the ability for it to be used by a lot of different parties at the same time. All right, so now that we have an understanding about what are tangible and intangible assets, so let's now go into the different kinds of IA and IP. So at the top part of the screen, you will see the orange bubbles. So those are the different kinds of IP rights. And starting from the left three most, so patents, trademarks, and designs. So these are IP rights that you actually need to register with the IP office in order to get protection for it. And for copyrights and trade secrets, you don't actually need to register them in Singapore's context. Okay, so some other countries require registration, but in Singapore, for copyright, you don't actually need to register them. So the rights actually automatically exist the moment you have the copyright or trade secrets in place. Right, so what are these different kinds of IP rights? So for patents, it's basically an exclusive right, which is granted for an invention. So an invention could be a process or method of doing something new, or a new technical solution to a problem. And I want to dispel this notion where patents has to be complicated. It does not have to be, okay? So case in point, your very humble toilet roll holder that everybody has in your bathroom, right? That toilet roll holder itself is actually subject to many different patents, more than a dozen in fact. So I just wanted to dispel this notion to say that patents have to be complicated. They need not be, okay? So what are trademarks then? So trademark is actually a sign that's actually capable of distinguishing the goods or services from one enterprise or one company to that of another company. So of course, your classic example is the McDonald's golden arches. Even a 3-year-old kid driving past a McDonald's drive-through will know that, okay, that's the place where I can go my fries and my Big Mac. Right, so what about industrial designs? So industrial designs relates to the visual appearance of an article. Okay, so purely on the aesthetics of it. It does not protect how the article works. And the usual places where you see registered designs are, for example, furniture design, automobile design, and jewelry as well. Okay, so those are some of those typical places where you see registered design protection. Of course, then copyright is referring to the rights that creators have over their literary and artistic works. And copyright is probably one of the most commonplace kind of IP that you actually come across in your daily lives, because this can cover anything from books to music, paintings, sculptures, photographs, computer programs, databases, advertisements, and so on and so forth. And finally, moving on to trade secrets. Now, as the name suggests, it is basically information that is actually not available to the public. So examples of this could be, for example, your secret blend of herbs and spices in a KFC, or your secret blend of ingredients in the Coca-Cola recipe. Now, when IP is typically discussed, right, a lot of people will be thinking, okay, this is a very legalistic concept, very legalistic perspective. And what comes to mind is typically what we are looking at, which is the orange bubbles at the top. As a result, right, many companies may believe that they do not actually have any intangible assets to manage because they're only focused on these traditional forms of IP. Now, the truth of the matter is that most businesses will have a lot of valuable intangible assets. And when we talk about intangible assets, right, then the discussion is broadened. So if you take a look at the purple bubbles at the bottom, right, so intangible asset is actually a larger asset class. So you'll see that intangible assets will cover things like, your know-how. So like in the case of McKinsey, you have different kinds of consultants that bring in their know-how that they have actually acquired. So know-how can be kind of like experience as well. So this is actually one of the very huge intangible assets, the know-how of the people within your organization. So if you are a company that actually does systems and processes like GE, so that is your other know-how. And if you are a company that does, pharmaceutical drugs, your regulatory approvals for you to be able to start to sell your drugs, that's a very important intangible asset to you. And of course, we have domain names. And if you are like a company like Google or Facebook or Meta, as they are called these days, where you collect a lot of data and make a meaningful analysis from it. So your data and the analysis that you make from it is actually your key intangible asset. So I just wanted to highlight this point, which is when we talk about IP and IA, right, it's really not just the orange bubbles at the top. We are talking about a much, much larger group of assets which you need to be aware of. All right, so now that we have an understanding about the different kinds of intangible assets, don't view them as separate items, because in one product, in this case that you see on the screen, you can have multiple intangible assets or IP actually holistically protecting the product in question. So in this case, what you have here is an espresso machine, which I'm sure most of you will probably have one of them at home. So within this Nespresso machine, you will see that there's trademark protection for the Nespresso logo. For the milk frother, you have a registered design on how it actually looks. For the extraction of the coffee from the capsule itself, that's actually protected by a patent. And what kind of coffee beans, the different blends of Robustica and Arabica kind of beans coming from the highland of Cameroon, for example. So the secret blend, what is the blend that goes into the capsule? That's a trade secret or confidential information. And of course, when you have your marketing brochures and your advertisements and so on, so those are actually covered by copyright. So as you can see, in one single product itself, you can have multiple layers of IP protecting it. And I think that's a very powerful concept for you to keep in mind. So we talked about one product. So let's take a look at a company, for example. And looking at this example over here, which is a telehealth company, which has kind of like, it's the rage over the past 2 years because of COVID. So people are not really going to the clinics. Instead, they are going through this telehealth consultation in order for them to have a chat with a medical practitioner and then get the medicine dispensed. So if you look at this whole value chain within here in a telehealth startup, you will see that there are many different kinds of intangible assets that actually hold within the company. So starting from the trade secrets on the know-how for the software and the design of the software. So for a telehealth company, a lot of times it's about how do you get the necessary kind of clientele to actually join. And one of the key things you might be looking at is that, okay, how is it that when a person is sick, it's easy for him or her to access my app to reach out to a medical practitioner and get the medicine dispensed. So the whole flow of things has to be very easy, because when you're sick, you probably don't want to be clicking too many buttons in order to go and join a call with a doctor, right? So the design of the software, the processes behind it, so those are your trade secrets and know-how. And of course, within this platform, the networks are very important. How do you actually link up the pharmacy together with the medical practitioners? And then how is it that you automatically update all this information into a secure cloud? So all these things are your networks and of course your data on your customer and patient data. How is it that you protect it and ensure that it's actually safe and free of breaches? So of course, then you have your brand. So you'll be building up a brand along the way and copyright for your marketing collaterals. So as you can see, within a telehealth startup, there are a lot of different kinds of intangible assets in there as well. It's just that maybe you haven't actually realized that these are your key intangible assets. Okay, so now let's delve a bit into why and how intangible assets should be considered strategic assets to your business. So if you look at this chart, right, I want to bring your attention on how intangible assets can actually generate value for your company. Now, as you can see from the previous slide about an espresso machine, right, if you are now a new company trying to enter the space of the coffee dispensing machine, there are many different layers of IP rights that you actually need to overcome. Okay, so as you can see from this slide, if you have a successful product such as an espresso machine and you have strong intangible assets to actually protect it, right, you can continue your sales at a higher price point for a much longer period of time. So that's being highlighted in the purple line. Conversely, if now you have a successful product, however you don't have the necessary intangible assets to actually help to protect your product, so you will start to see competition coming in and eating away at your market share. So that's where while you can have a sales initially, which is very good, because of this new entrants coming in and you can't actually keep them away, right? You'll start to see that your sales will actually start to drop along with time. And of course, if you have a unsuccessful product, then of course we're talking about low sales over here. So I just want to highlight that for this slide is really for you to understand that your intangible assets can be a very strong business tool and leverage for you to actually help to keep out competitors. So expanding on that point a little bit, you will see that depending on the strength of your intangible asset, there are many ways of actually deploying it. So if you have weak intangible assets, you probably have one way, which is, okay, I will continue to use my intangible assets myself. If you have a bit of an average IA, so you can look at slightly more different ways of monetizing it. So if my intangible asset strength is actually average, I could use it myself. I could potentially also license it to somebody else. Now, if I have really, really strong intangible assets, right, I could even license it to somebody outside of the field of what I'm practicing in. So let's give example, if you have a patent, for example, that actually protects a particular kind of face mask material. So if you have strong intangible asset, that particular material can be used not just in face mask. It could also be licensed to use to say a air purifier manufacturer. So they could actually use your material to actually put it inside their air purifying machine. So the strength of intangible assets can actually bring you other different kinds of opportunities. Right, so we talked about what IA and IP is and of course the importance of it to the business. So really, what's the value of IP or IA? So taking a look at this slide, you will see that for the various different phone manufacturers, from Huawei to Samsung to the Apple, right? Sorry, this slide is a bit old, but generally this is still the gist of the story. The success in the smartphone industry is based on intangibles, because if you look at the numbers at the bottom, the blue numbers, right, it says that Huawei and Samsung and Apple's value capture using their intangible assets based on the price of the phone, right? They're talking about anywhere from 34 to 42%. So this is minusing away the other different costs, right? So cost of the materials of building up the smartphone, for distribution and retail, probably also for advertisements and R&D and so on and so forth. So if you take away those other costs, the value attribution for each phone, you're talking about anywhere from 30 to 40% through intangible assets. So as you can see, intangible assets can really provide a huge value to your company. Right, so let's take a look at how is it that you can then actually manage your intangible assets. Right, so intangible asset management is not a new study or method, right? So it's really about recognizing what gives value to your business. So traditionally, as you can see from the screen, you will tend to tag your physical assets. So like, your laptop, your tables, your chairs, your monitors, and so on in the office, right? Or at least I hope you do. So even for the cattle that you see on the screen, the cattle has been tagged by the farmer as well in order to track where they actually roam to, right? So if we care so much about physical asset tagging, what about intangible asset tagging? It's something that doesn't seem to be quite done very often. Why? Maybe it's because intangible assets don't really get flagged up, or you don't really get to see, touch, or feel it. So just because you can't see, touch, or feel it, right, does it mean that it doesn't have a value? Okay, I hope I've illustrated that it does have a huge value contribution to your company. And just because you cannot touch or see or feel it, right, it doesn't mean that it should be, put in some cold storage somewhere. So really, for your intangible assets, you need to be able to keep track, and you need to be able to get a manifest or a inventory to say what are the assets I have in place in order to protect them, and in order to use them just like you would use with a physical asset. And I think this point is really important for startups, because think about it, you as a startup, what are your key physical assets? You probably have a table, a chair, some laptops lying around, and maybe a coffee machine. But beyond that, it's really your intangible assets that will actually help you to propel your business growth moving forward. So do put an emphasis on tracking what your intangible assets are. Okay, so you need to, of course, plan for your IP strategy at a very, very early stage of the business, because your IP strategy cannot be a standalone strategy. It has to tie in very, very strongly together with your business strategy. So when you are identifying your market, you are also identifying your IP assets. So when you are looking at market adaptation, so your product may suit a market in Singapore, but may require some adaptation overseas, then you need to change your IP protection accordingly as well when you actually start to move overseas. And of course, when you have business follow-up, then you also need to think about IP enforcement. If someone infringes on your rights, what are you going to do? So the point I want to emphasize here is that your IP strategy cannot be a standalone strategy. It has to support a business strategy. So knowing where you want to go in the next 1 year, 3 years, 5 years, then that's where you can actually plan to have your IP strategy to back up your business strategy. Now, I understand that it can be quite difficult to say, okay, right, intangible asset tracking is important to me. Where do I start? Because, yeah, really, where do I really start? Because it's something that I can't really touch, see, or feel. So we have this framework, which is called the MAD Growth Framework. So MAD for short, which stands for Market Advantage and Drivers. So for the market, we help you to say, okay, this is a structure you can follow. So identify first, what is your market? So what's your business model? What are your products and services? Who are your customers? So basically, who pays you? Is it the end client? Are you a B2B business? Who are your competitors? So identify your market, who are your customers, and then who are your competitors. So once you've done that, move on to the next stage, advantages. So why does your customer actually choose you over competitors? Is it you are cheaper, better, faster, or is it possible that you are cheaper, faster, and better? Right, so you need to know what your competitive advantages are. So once you've identified that, the next stage is that then what are the drivers that allow you to do that? So how can it be that you're cheaper? Is it because you have a better manufacturing process? You have found, the correct network of people who can actually manufacture cheaper for you? How are you faster? Same thing, is it a manufacturing process, for example? How is it better? Are you using better quality components, and so on and so forth? So once you are able to identify your enablers, that's where you can then identify what are your key intangible assets in your enablers. Okay, so I hope this framework is useful for you to be able to identify what your key intangible assets are. Right, so now I'll share with you some of the initiatives that IPOS and IPOS International have come up with to help enterprises to leverage your IA and IP. So the IPOS Go Mobile is actually an app. So this app actually helps you to register for your trademarks very quickly. So all you need to do is really to log into this app. And within this app itself, you can, when you're registering for your trademark, right, it will help search through business names, trademarks, web domains, social media usernames. And within the app, then you can submit for your trademark application, and very quickly you'll get an estimated cost understanding, and the whole process of the registration can be actually done through the app. So one of the key things we always talk about is that you need to build up your brand. So the trademark registration is one of the most important things you need to look at. So using this app actually shortens the time a lot more. Okay, right. My time is coming up soon, so I'm going to rush through the next couple of slides. So for this next part is the Singapore IP Fast Track, which is talking about, because the patent application process can be quite a long one. So the Singapore IP Fast Track was actually launched about 2 years ago. And essentially what we have here is that you can have a fast track to actually get a patent granted in Singapore under 6 months. So just to give you some context, a typical patent application within the ASEAN region ranges from anywhere to 2, 3, 4, 5 years or even more. So to have a patent granted in 6 months is especially useful when you're a startup, when you're unsure about, okay, this technology, is it going to work? So having this certainty will help you to also talk to your investors. And associated trademarks and registered designs to that patent can also then be granted in under 3 months and 1 month. Yeah, so if you have your smartphone ready, just take a QR code, scan a QR code on the screen so that you can be linked to this site to find out more about this particular Singapore IP Fast Track initiative. So for Singapore, you do get certain tax exemptions when you actually invest in your IP. So whether it's investing in your in-house IP that you create or actually licensing in from third parties, right? So the amount depends on what kind of activities there are. So this is just a very quick overview slide, and I won't go through the details. I'll be sharing with you the slides later on, so don't worry. This slide is just for information. Just know that there are tax exemptions you can actually claim if you do have investments in your IP. And so this is actually an initiative by Enterprise Singapore, which is called the Market Readiness Assessment Grant. So if you are going to expand into other overseas countries, right, you can actually tap on this grant to help you to file for your IP rights, to help you to draft, franchising, licensing agreement, distributorship agreements, and so on and so forth. And of course, the eligibility is that you have to be a Singapore company, registered in Singapore, 30% local shareholding, and so on and so forth. So up to 70% of the eligible cost capped at $30,000 per company per new market. So this is quite a useful grant. We're talking about per company per new market. So each market you can actually apply this grant. So each country you go into, you can actually get this grant over there. All right, and last couple of slides. So resources from IPOS and IPOS International. We have a series of business guides. So depending on whichever stage you are in terms of your journey, so whether you're actually just starting up, so you're looking at what are the rights that I need to procure, or you're starting to go into collaborations, or that you want to have an idea about how is it the IP is being valued. So these are the different guides that we actually have for different stages in your business expansion plans. So there's a total of 15 of them. Again, scan out the QR code so you can actually download them. And finally, we do have this complimentary intangible asset chat sessions. So if you find that you do have some further questions after today's webinar and you would like to speak to someone, right, feel free, again, scan the QR code. You can arrange for a chat session with us, complimentary, and we can go into a bit more details about how we can actually help you with your business. All right, so just a very quick overview. Identification is important. So you need to first identify what your intangible assets are, see how it actually correlates to your business. Of course, the managing of it is important because your intangible assets can be multiplied. So not just for your own use, you can actually license it to someone else, and that's another different kind of a business or monetization model. And of course, the cost of IP protection can be a bit high, and the speaker Kim Tean later he will discuss a bit more about this. But just bear in mind that IP protection, there are costs associated with it. So you need to apportion the different kinds of budget for the different kinds of IP protection. Right, and with that, I've come to the end of my presentation and my last slide over here. So any questions that you may have, feel free to type it inside the chat box, or just drop me an email at my email address over here. All right, so thanks so much again for your attention, and I'll pass the time back to Marcus.
Thank you so much, Eric, for this sharing on IA and IP and the importance of it. Really appreciate it. Now, to move on, we will now be looking at the important pointers to note when we are registering for IP overseas. And for this segment, we actually have Mr. Ng Kim Tean. And Kim Tean is the Executive Chairman of Nanyang Law, a law corporation headquartered in Singapore and has offices in 5 ASEAN cities. So Kim Tean's primary area of expertise includes IP law, and he has many years of hands-on experience that exposed him to all aspects of prosecution and management of IP portfolios and patents. So with this in mind, I'll be now passing the time on to Kim Tean.
Hi, good morning, everyone. Can you hear me? Just to make
Yes.
sure. Yeah, okay, good. Yeah, excellent. Yeah, thank you very much for attending this session. Well, I think we all get used to using Zoom now, and I still miss my coffee where we can meet in person in a hotel room or something like that, right? And I'm not going to introduce Nanyang Law in length. Basically, it's just a law firm. We have regional practices in many of the ASEAN countries because of reasons that were explained very shortly. And needless to mention, as a lawyer, I make money when you're in trouble. So that's what I do as a career, as a job, right? So without further ado, just let me carry on and start this session. The topic that I have today is interesting, and I keep it very layman. So no technical jargons, no legal jargons as far as I can. And well, even the title suggests that it's just going to be things to note when you're registering intellectual property overseas. So earlier on, Eric has touched upon the various types of intellectual property rights that a company or as an individual that you can possess, you can own. So I will not delve into the details nor describe each of them, but basically just a short description. You have just a patent right that you can own, trademark right, registered design right, trade secret know-how, copyright. So these are the common types of IP. And I assume that most of you would have, one way or another, encounter these rights either in your career as an employee or as an owner of a company or a startup. And this is not exhaustive. There are a few others which I'm not going to list them out. So you have other protections, like for example, you have the registered circuit design. So for those into PCB board, your circuitry design can be protected as well. You get a plant variety, so you are into agricultural products. The plant, the new hybrid, the new orchid that you come up with, it's also protectable under a separate legislation. So for those that are not too common, I will not touch upon them. So very quick introduction on the various IP rights, and we move on. So you know that you can protect your IP in IPOS. Eric has explained and expounded on that. So you protect your IP in Singapore. So does that mean that your protection that you filed in IPOS will cover you worldwide? Unfortunately, the answer is no. And the reason being simple, law is territorial in nature, right? And IP law being a branch category, a practice of law, it becomes also territorial in nature. So what does that mean? Meaning that every country would have different IP protection law, would have different legislations, different regulations, which inevitably would make the entire filing process, the registration process, a very complex one. And also when it comes to enforcement, the judges from the different countries would take different elements into perspective depending on the legislation in the particular country, right? So this makes the entire IP protection in different countries a very complex process. And but that's what you are faced with. That's what we have on hand. So nothing much we can do about it. It's just that we have to learn how to manage this. And fortunately, The good news is that although by nature, law is dilatory in nature, including IP protection, as I mentioned, there is an effort, right? Not just regionally, but internationally to harmonize intellectual property protection regarding the law and associated processes. So it is not a complete similarity, but certain areas, they try to harmonize them. So the law in one way or another appear or tend to be pretty similar. And also coupled with treaty protection, which I'll touch upon them, there would be certain application that you make in an international manner, which protects in the countries that you select. And we're talking about a big number of countries, close to 100 for some of the treaties, or even more, right? So IP protection, remember, law is dilatory in nature, but there is a persistent effort to harmonize the protection in the various countries, especially industrialized ones, right? So that's something that you probably want to bear in mind. So as I mentioned earlier, IP registration processes then would vary from a country to country. And as a IP owner, you will face a lot of problems in this regard because you have to deal with different countries in different languages. And Eric earlier mentioned about the cost. So meaning that you pay $1 in Singapore, when you file in, for example, United States, it becomes $1 Sing dollars. So inevitably, your cost goes up by about 34% quite quickly. So this is something that you definitely would have to bear in mind, in addition to the complexity, right?
Kim Tean, sorry to interrupt.
Yeah, sorry.
Yeah, that's good. Thanks.
Oh, okay. Sorry, it gets a bit softer. Yeah. All right. So this is something that you want to bear in mind. The cost is always a big element in addition to the dilatory nature, right? And my advice most of the time, and in fact, to all my clients, is that it is good. And many of the owners would say that I want to file, and they come to see us and they say, well, I want to cover as many countries as possible, which makes sense because for every country that you don't seek protection, or you don't file a patent, or you don't file a trademark, then you don't get protected in that country, unless you use a treaty, which I will touch upon later, right? So if you go to a specific country and you do not do it for another, then there's no protection. So it makes sense from a logical point that you should cover as many countries as you can. But you have to bear in mind, every country you have to pay a separate set of fees and go through a separate difficult process, as I mentioned, right? So right from the start is something that you definitely have to look into and bear in mind, though as many countries protections, which is ideal, there's associated cost involved, time involved. So you really make sure that your IP portfolio is aligned to your company's overall business strategy, right? Before you mount on this exercise. And unfortunately, something that I definitely want to remind all the business owners, when you start this IP protection, right, it's a lengthy process. How long? For example, for patent in some countries, just to get it granted, meaning that the government allows and says, well, I not only accept your registrations, but approve it, that takes as long as 8 years, right? In some countries. So can you imagine over 8 years, you have to keep paying, right? In segments. So there are many, many milestones, and each milestone you have to make payment for that particular step of the application process. And so you can imagine it's going to be a very costly affair. And unfortunately, it's what I always call is like a poker card game. When you start the journey, you can't stop. And when you stop, whatever you paid earlier will be down the drain. So imagine you said that, well, I want to start a patent process in Singapore, USA, Japan, Korea. And halfway through, you decided and said that, well, I really cannot afford my Korean and my Japanese application. And you say, well, I am 2 years into this, but my funding is getting lesser. So I want to continue only with Singapore, with US. I'm going to give up Korea and Japan. Which means that the money you will really pour into Japan application and into Korean application is gone. So it's a poker card game. It ends the moment you decide to abandon. Lawyers, we are not going to refund you back. The government agency is not going to refund you back on the official fees that you paid. So these are factors that you really have to consider and make sure that you can last this journey, which can be a lengthy one, right? And so I touch upon it. The IP registration can be costly, and quickly a few key items that would absorb the cost and something that you probably have to really seriously consider. One, remember IP registration involves legal processes. So not everyone can do it. Well, I thank Eric and IPOS for the effort where often you can just do a registration on your own, and it's easy to navigate the IPOS website and file the registration on your own. But we cannot say that for many other countries. In many countries, it's so difficult to use and to file it on your own, meaning that you have to appoint an authorized agent to do this job for you. So like in Singapore, we have patent agent like myself. So I charge a fee and I am a professional doing this. Many lawyers can do this as well. And so appointment of authorized agent is important and it costs money. And unfortunately, as a lawyer in Singapore, I only can advise and practice and give you registration rights only within the territory of Singapore. That's why it's territorial in nature. So I do not have the authority to represent you in, for example, Malaysia. I can't do that for you in Vietnam. Meaning that you have to appoint a separate authorized agent, like a trademark agent or a patent agent in the jurisdiction that you want to file your IP protection, right? And that obviously, needless to mention, that costs money because there's a service fee related to that. Next, you have to take into consideration when you file in Vietnam. So the Vietnamese government, the IPOS equivalent in Vietnam, would not be able to understand, accept your or would not be able to accept, not understand. Even if they could understand, they would not accept it because they would expect any application to be filed in Vietnamese. So you need, although you have an English version, you need to do the translation. And you may say, well, but Mr. Ng, so translation, it can't be that expensive. Unfortunately, it is very expensive. How do we charge? They go by per 100 words. So 100 words would cost you something like close to a few $100 sometimes, depending on what language, right? Or tens of dollars. So a translation alone can cost as much as, for example, a patent specification which you need to file and is written in English. When you file that language in Japan patent office for a maybe 20-page patent specification for those who are familiar with the process, that would cost you easily about 8,000 to 9,000 Singapore dollars just for translation alone. And bearing in mind, this translation you can't do yourself because many of the patent officers would require some what they call it, a translator to authorize and stamp with a piece of so we call it like a VET, meaning that it's verified. The person who is translating the documentation is actually a professional, and he must stamp his name and his professional qualification, qualified to translate the documents for you. And to make matters worse, because your technology can be medical related, can be semiconductor related, there are many technical jargons. So not ordinary translator can do this job for you, right? Because you will lose the meaning when there are technical terminologies. Like for example, COVID in Chinese you just can't translate it in this manner. You have to say 观点, 肺炎 or whatsoever, right? So there will be related technical translator, technical jargons that you need for translation purposes. And of course, needless to mention, you have to pay the government that is going to process the application. So all this add up as a ballpark, if you ask me. For a very easy start, if you file, let's say, a patent application in 3 countries to 4 countries, right? 3 to 4 countries. And it involves maybe, let's say, Japanese and Chinese, right? In China and Japan, and Singapore, and let's say America, which is an English-speaking country. The cost alone for initial stage would cost you easily about $50,000 to $60,000, right? Up to maybe 12 months. So for the first 12 months of your application process, you already have to set aside a capital outlay of about 60,000 for 3 to 4 patents. So it's something you really have to bear in mind, right? When you protect overseas. I talked about it, right? The translation of IP document is very expensive because of the technicality involved and and explain, you need a professional translator to stamp on the translation document, which is going to be filed with the registry, right? And I also mentioned that time is a lengthy one for IP registration. So the IP, for example, like patent will take about 20 years, the protection. So every year you will need to pay renewal, and the initial, until you get the approval that the registry approves your application, will easily take even 2 to 3 years, typically in most countries, and as long as 8 in some other countries, right? So this is something really you have to bear in mind. And of course, as I said, the IP registration process is a very complex and difficult one. So something that you really need a professional to do it for you. Often you can do it yourself, but you will understand how difficult it is. And as I said, if you miss a deadline, it could also mean that it's a poker card game, whatever that we invested will go down the drain, right? So it is advisable that you should get a professional, a patent agent, a trademark agent, or industrial design agent to do this process, to this application process for you, right? And something that I think is important, as I touched upon earlier, not just aligned with your company's strategy, you also want to make sure that the entire registration strategy, right, is harmonized and is synchronized across the various countries that you seek protection, you sought protection in, right? So this is something that, again, if your portfolio is big, I would even advise you to hire internally, right, for a team of patent trained staff to synchronize this for you. Just a very quick detour from here. If you are familiar with patent process and you have done one or two on your own before, or instructed a patent attorney to do on your behalf before, you realize that a patent process is long because when you file a patent, for example, or even a trademark, the patent office or trademark office would actually examine what you filed and see whether it meets the legal requirement. And if it doesn't, for example, like patent, if it doesn't, they will issue you what we call office action. They will say, no, I disagree. I think your invention is really no big deal. Someone has already invented it before. And every country would do their very own investigation or their own examination, which is the legal terminology that we use, right? So when they reject, often your invention is the same, but the replies from different registries done by the patent examiners, we call them, will be different. But you can understand that there are some that will be overlaps. So if you are able to synchronize it with a single, either appoint a team of internal staff. So if your Japan authority comes back and say, well, I disagree with the patent because this point 1, 2, 3 are no good, and likewise, in US, they come back and say 1, 2, 3, 4 are no good. These are the reasons why I'm going to reject application. Please explain yourself. You will know that what you have explained in Japan office point 1, 2, 3, you can recycle it in America application, right? So there would be some synchronization effort that would save you a lot of cost and effort as well, if you can have a single team. If you don't have internal staff, then my advice is often to get one set of lawyers, and they would do the other countries for you. So you always have a point-to-point contact with one, for example, like Singapore, and we do it for various clients in various other countries. They only link with us as a single point of entry, and then we will do the overlapping for our clients on their behalf. So it's something that you want to think about, right? I think the most important, as I mentioned, is earlier on, that time is always a big concern. Cost is a big concern when you file overseas. And inevitably, as a business owner or a decision maker in the company, you always want to say that, well, I want to cover as vastly as possible for my IP protection. So you have this difficulty where on one hand, you want to do as far and as many as possible. On the other hand, there's a cost constraint, there's a budget constraint, there's a time constraint, right? And fortunately, as I mentioned earlier in the preamble, in terms of the various IP protection processes, the law is territorial, no doubt about that, but certain processes are synchronized, certain processes are harmonized, right? So you should make use of all this harmonization so that you can file international treaty that covers and protects your IP protection in a wide territory, but with minimum cost or minimized cost, right? So these are some of the concerns that you want to take into consideration when you develop your IP protection strategies overseas, right? So very quickly, I think because of time constraint, I'm just going to touch upon a few. Remember, I started with patents. So it's difficult. You will need a professional, a lawyer, a patent attorney to guide you along, but these are some points that you can actually throw at them and say that, well, next time if I want to file patent, I want to file using PCT, for example, which stands for Patent Cooperation Treaty. So this treaty is signed by more than 150 contracting states, right? It allows, so you have the protection in many countries, right? It's like an international protection thing for many, many countries. And you only file one single application in Geneva, in WIPO, and one single application you can protect in many, many countries. So you save costs, you save in terms of language translation, as I mentioned earlier. So this is something that, yeah, as I mentioned, you save cost, money, and it's only one application that's needed. Except that, unfortunately, as I said, they harmonize the law, but it's not complete. So often you will hear that people say Patent Cooperation Treaty is an international patent protection, which is partially true, not wholly, not fully, because as I said, the patent protection process is a lengthy one, right? So assuming for simplicity, you have, let's say, 10 steps, right? When you use PCT, they harmonize it only the first 7 steps. So the first 7 steps, you can use an international application where things are in single language, you only pay one fees in one language, a single cost, right? Unfortunately, the last 8, 9, 10 steps, you still have to go back to the respective countries. So that is unfortunately a disadvantage, but unfortunately, this is what the law is, and I think it makes a lot of sense. I always said it in my lectures and seminars, is as if you file a protection in, let's say, international PCT in Geneva, right, and you have protection in Singapore for step 1 to 7 in terms of the application process. If Singapore IPOS doesn't make money for step 8, 9, 10, then you would have a very, very busy Singapore police enforcing your rights where no payment has been made to IPOS. So basically you pay to WIPO, but our Singapore police, who is supported by the Singapore taxpayers, will be busy trying to enforce your patent infringement in Singapore, and IPOS doesn't gain any monetary return for that, right? So I think it makes some sense that often the international treaties would allow you to have a combined cost saving for initial maybe step 1 to 7, and then the last few steps you still have to go back to the respective countries where you want the protection. But it's still a very substantial cost saving that you want to bear in mind. I wouldn't delve into the difficulty because it's really complex. It's something that you want to tell your agent, your authorized patent agent, say that, well, I want to file in many countries. Maybe you want to start PCT and explain more what are the steps and what are the benefits, right? This will take one whole session on its own, but something just in your plan, in your mind, so that you're aware of this treaty that helps you to save cost and time. Next is another treaty that is signed, a Paris Convention, they call it. This one is, again, the purpose is more for the purposes of time saving. So it actually allows you, you can have the slides later on, so I won't go into the theoretical part, but practical points to take note of is that when you file your application, let's say in Singapore, right, and you have a corresponding countries that is also a signatory to the Paris Convention, right, and you want to protect, let's say, in USA, right? Traditionally, you file in Singapore, at the same time you file in US, so you incur 2 sets of costs, right? One set in Singapore dollars, one set in American dollars. But if you rely on Paris Convention, so today is January, you file a patent application in Singapore, right? You can wait for 12 months, right? So by December, end of this year, you say, well, I think there is a market, not only a paper projection in January, February of this year, but really my BD manager managed to develop that business in US. So I want to file in US now, December, right? This Paris Convention allows you to file in December, but your protection is crawl back and starts as though like you're filing in January. So you save a total of 12 months. And that time allows you to think and to actually explore your paper plan and to make sure that when you spend the money filing in America, you know that there is really potential, a business potential, with 12 months of marketing research time that you have to do, right? So this allows you to have a 12 months of lead time. And the beauty of this treaty is that although you're filing in December, the filing date is the protection starts 12 months backward, as though like you filed it in Singapore in January, right? So that's something that you want to make use of as well. Again, it's a complex process, something that you want to throw it out to your patent agent when you file a patent and say that, oh, I want to use Paris Convention, right? So something that one plan in your mind as well. And I think Eric touched upon that. There are certain speed up processes in today's context because patent is important to get it granted quickly as you can. So there are certain patent prosecution highway which are signed between countries. So this is very specific. So a country and another country will sign a PPH, like Singapore and Japan has got a PPH. This one typically doesn't really, the main purpose of this is to expedite the cost. So remember I told you about 8 years in some countries. So if there's a PPH, then you can speed up the entire process considerably down to only 1 or 2 years, 2 to 3 years, right? So it's something, this is for time saving purposes. Yep, I think Eric touched upon the fast track thing earlier on. It's something new just for IPOS, but between IPOS and Japan. So you file in Singapore and you say, well, in Japan it's a bit slower, I want to file it quicker, you can rely on PPH, Patent Prosecution Highway. So there's a treaty only between Singapore and Japan, Singapore and another country. So it's actually between 2 countries, but Singapore has signed many of these treaties with the various other countries to speed up the process, right? And this is also unique. There's another speed up processes in terms of cost saving and time. It's called ASPAC, ASEAN Patent Examination Corporation. So bear in mind, this is only applicable to ASEAN members, right? Brunei, Cambodia, Indonesia, Laos. So if you're filing in these countries, unfortunately, many of these countries are a bit slower in terms of the patent prosecution, the patent application process. So if you rely on this ASPAC, it will shorten the process considerably as well, right? So this is something that you want to take note, especially when you want to have your application expedited. Yep, so this is the benefit, again, time saving. Yep, and I want to touch upon, Trademark has got similar system, right? So the most common trademark application for treaty purposes, we always use Madrid protocol, Madrid application. Why it's called Madrid is because this treaty was signed in Madrid, so they name it after the city the convention was held, right? So this one, when you file a trademark application, all you need is that you can tick as many countries as you want, up to 125 countries, and the trademark protection will be permissible in all these 125 countries. So again, single language, single application. Likewise for like patent, again, yeah, so it's a single application in one language. You only pay one set of fees and you protect in multiple territories. Again, there is a disadvantage in that sense because there are 2 steps that you need to do. If you want to file Madrid, for example, in let's say you selected 5 countries, right? In Japan, US, and a few others. The more ticks you have, you pay for every country that you select. But of course, it's going to be much cheaper than you go to that country and file a brand new application. If you understand what I mean. So if you file in Singapore and US, independently, you have to file 2 sets of fees. But if you use Madrid, you file Singapore, you tick US. Then you only file 1 set, but 2 ticks. Of course, you pay a bit more as opposed to just ticking Singapore. But the cost saving is definitely tremendous compared to you going to US, filing a brand new application. Except, as I touched on earlier on, there are 2 parts. One, in order to file in the other countries, you must file in Singapore first. IPOS requires you to file in Singapore first. Only when you file in Singapore, then you can rely on Madrid to file in the other countries. Second, again, the steps are not complete. Again, you only have step 1 to 7. Last 3 steps, you still need the country. Still need to pay the respective countries. So when you file the Madrid, if it's a smooth, fine. If it's not smooth, as I said, remember you file because the trademark examiner will come back with questions and say that your trademark is not registrable. So for example, in China, they say, in let's say Korea, they say, well, your mark is not registrable, right? I want to oppose this mark, right? And unfortunately, you can't rely on Madrid. You take Korea, but whenever there's an objection from that country, patent or a trademark office, you still have to appoint a Korean trademark attorney to argue the case and convince the trademark office in Korea that your mark is unique and should be registrable. So again, you have that constraint for trademark. Registered design, same thing, is a Khoo convention, Khoo system. So this allows for all registered design, same advantage you have. Again, filed in one country, again, you get protections in various other countries with a single set in one currency. So, yep, I hope I'm still within the time. Sorry, with the slides, I can't see my time. I can't see any other things about my entire computer, just other than the slides. So I think I should be within the time. Thank you. So just my email is here again. If you have any questions, you can drop me, or you can leave it on to the later Q&A. And thank you very much for your attention. Sorry for rushing through, but I only got 25 minutes, 20 minutes. I hope I'm not outside the time. So
no worries, Kim Tean. Thank you so much for the comprehensive
I'll give it back
sharing.
to you. Yeah, thank you very much. Yeah.
Thank you.
Thanks.
So I think Kim Tean has shared with everyone a really comprehensive overview of registering or IP overseas.
Thank you very much.
Yeah. Also, with regards to the slide circulation, I think some of the guests have shared that they are keen to know more about the slides. So we will actually be sending out an email later on with the slides for circulation. And also, if you have any questions, please put them into the Q&A box, because after this session, you actually assist with answering the questions and emailing them out. Okay, so thank you so much, Kim Tean.
Yep, no,
my
pleasure.
With an understanding of what to note when registering for IP overseas, we will now take a dive into how local startups can grow beyond their boundaries. And for this segment, we have Mr. Colin Koo. So Colin is the Principal Technology Manager of Innovation Partner for Impact, or IPI for short. And Colin leads the Science and Engineering Cluster in IPI in deep tech due diligence, technology scouting, and open innovation activities. And he supports enterprises in the infocom and electronics domain. So without further ado, I'll be now passing the time on to Colin.
Thank you, Marcus, for a kind introduction. You can hear me and see my slide?
Yes, crystal clear.
All right, thanks, Marcus. So hi everyone, thanks for attending this session. So my topic, I'll be talking about supporting local startups to grow beyond boundaries. Right, so Marcus has introduced me. So basically, I have done product design electronics for the past 18 years before I joined IPI. So in automotive, consumer electronics, mobile devices, or life science instrumentation. So for those in product design, I know your pain. I feel you. All right, so let me go on. For IPI, IPI is an innovation catalyst that creates opportunities for local enterprises to grow beyond boundaries. So beyond your geographical boundaries, beyond your technological or technical boundaries. We accelerate the innovation process of local enterprises through access to our global innovation ecosystem and advisory services. We are a subsidiary of Enterprise Singapore. So research institutions, institutes of higher learnings, etc. And we have our local and overseas SMEs and startups, as well as our trade associations and chambers, government agencies, and commercial IP intermediaries. So why work with IPI? We are a neutral party. We understand your current innovation needs. We aim to source for the relevant technologies, expertise, and partners that best serve your needs. For our people, we have a multidisciplinary team of innovation managers and technology managers, as well as innovation advisors. We have deep expertise and experience in diverse technical domains and industries, as well as business acumen to provide insights during our engagement with you. For our network, we have a wide global network of industry and technology partners, and we can open many doors for opportunities for cross-sector and cross-border innovation partnerships. Now, how startups can benefit from IPI's portfolio of innovation services? IPI, basically, we have a broad spectrum of innovation services. And today, I will highlight those that can be relevant to startups and I will talk more in detail in my subsequent slides. So for our open innovation services, you can look at innovation challenges. For our innovation advisors program, you can look at the innovation advisory, and our innovation marketplace, you can look at our tech office, tech needs, and tech experts. Right, let me go in detail. For our innovation challenges, so as a startup, you can tap into IPI's open innovation challenges to co-innovate or co-develop with MNCs or large corporates. So for innovation challenges, basically the MNCs or the corporates, large corporates, they have certain problem statements, they have certain pain points that they're seeking to solve. So what they do is they come to IPI, help them organize innovation challenge. And in this challenge, they put up their problem statements, their pain points to crowdsource for innovative ideas from everyone. So it could be from SMEs and startups, and sometimes these innovation challenges are specifically for collaboration with startups. These are some of the open innovation challenges that IPI has done before in the past. So for example, our crowdsourcing at Tech Innovation, the corporates that are involved or the problem statement sponsors. For example, we have like Shell, Unilever, WS, Audiology. Like in our Sustainability Open Innovation Challenge, we have JTC, Capital Land, Changi Airport Group, Lendlease, NEA. And our Trade and Connectivity Challenge, we have Continental, Singapore Post, SETS, Sumitomo, and YCH, etc. So you see, as a startup, you can actually make use of these problem statements to help you in a way that you know that you are solving problems that are a real market need, and you can make use of this to drive your product development as well, as long as they can solve these problems. And in doing so, you can also enhance your team's capabilities. So this is a good route to explore. Here are some of the success stories. So for example, for Movita and Su Technologies, Movita is our local startup. They learn about our Eureka Global Stars Singapore Joint Innovation Call in 2019. And they discovered each other through this call, which we helped to put up. And together they developed external HMI software that can help autonomous vehicle fully assimilate with the urban environment. So there's a collaborative effort going on. And in doing so, you see that there will be some kind of a technology collaboration to help accelerate products to market. Another example would be Opava AI and China Construction. So Opava AI is a smart construction tech startup, and it was selected to develop an automated drone photogrammetry solution for China Construction. So this is through a BM call, which is a multi-agency call that is supported by IPI. And we see that through this collaboration, Opava AI strengthened their R&D capabilities as they developed this for China Construction, and they expanded their software capabilities. Another example would be the IoT Innovation Challenge that's organized by IPI, Enterprise Singapore, as well as the Center of Innovation for Electronics and IoT in Nanyang Poly. So basically, this call is to answer to ASTEC and Singtel's problem statements. And through this, it has helped our 4 Singapore startups, SpaceX Labs, SenseUp, Avis Health, and ProSpace, fast-track their growth goals. So because in developing the products, they are also able to fast-track the internal R&D capabilities. Next, our innovation marketplace. So this is a self-service online platform that allows technology seekers to be connected to technology providers and technical experts. So basically, as a startup, you can go through IPI's technology offers to look for complementary technology or collaborators to accelerate your product development efforts. So technology offers technologies that are hosted by companies. These technologies are available for collaboration use. They are not wholly end products, meaning to say perhaps there are subset or subsystem, submodule, perhaps a piece of algorithm that is not a full, complete product yet, but they are available to be, for example, integrated into a bigger product or available for licensing. So for example, you're a startup and then you are doing your product development, you lack a specific piece of module. It may be a hardware module, maybe an algorithm, for example, and then you don't have in-house capability to develop that. You could try finding this in our tech offers. They may be tech offers that are a specific portion that you need. You could get in touch with them through IPI, and then you can collaborate, co-develop, and go to market faster because of that. Also, you can find tech needs. These are actually problem statements or pain points posted by companies that actually are seeking for people to solve their problems. And as a startup, if you find that, hey, your technology is able to solve these tech needs, then you could get in touch with them through IPI and put your solution to good use. And in that sense, you also fast track yourself to market. There's another part for the online marketplace, that's our tech experts. So enterprises can engage our tech experts from different sectors and different domains to solve technical challenges that are encountered in various stages of your product development journey. So as a startup, you may not have sufficient in-house technical expertise yet, right? So for example, you may be ramping up your team, you may be getting people in, still putting the different pieces together. So you can get help from these tech experts in the various different domains. You could go to our portal. We have 100 plus tech experts in our portal now. You could search for those that are specific in your domain that could help you. So our tech experts, they are typically researchers or academics or service providers or consultants or freelancers that are in industry. They have at least 10 years or more of experience in industry or academia, and at least one area of technical expertise. So they could be in consultancy, product development, regulatory compliance, or tech translation, or scale out and commercialization. So they could be based in Singapore or overseas, but then they have a keen interest to work with you, our Singapore enterprises. So some success stories, Art Design and Republic Poly. So Art Design was seeking to enhance its corrosion resistance in one of its automotive care product, and then it was looking for expert to help them do that. So we matched them to Republic Polytechnic, and through this collaboration, they are able to create a new product, nano graphene coating, that is a step ahead in terms of performance. And it also gained its manufacturing process know-how, and therefore it sharpened their competitive edge. The other example would be In Vivo Medical and ITE. So they were first matched at IPI's Tech Innovation event in 2013. So between In Vivo Medical and Institute of Technical Education, National University Hospital, and NUS, National University of Singapore. So they are developing a device that can help to make the surgery in kidney stone surgery simpler and safer. ITE provided the expertise for the design, development, as well as prototyping of the device. Right. So one last example here, restoration essence and MRE. So pandan leaf, we use it for cooking, but can also be used for detox for the body and the skin. Restoration essence, so our local company reached out to IPI through an inquiry on our innovation marketplace. And through our help, we teamed up with researchers from Institute of Materials Research and Engineering, IMRE, to evaluate and improve its performance of its products that are pandan-based. So you see all these companies, they benefited from working with these tech experts Now, let me go on to the other portion, which is our Innovation Advisors Program, or IAP as we know it. It supports Singapore enterprises in their innovation journey and accelerate their growth through customized advisory. So this advisory, they're done by industry veterans who are bilingual in both technology or innovation, as well as in business. And the program provides customized advice to guide strategic thinking, insights and know-how to accelerate companies' learning, as well as industry and technology networks to facilitate and implement your strategies. This program helps to develop differentiated value propositions for products and services or business models, and helps to accelerate growth in areas of competency, operations excellence, accessing of new markets and new revenue streams. Typically, our innovation advisors, they are former C-suite people. They're bilingual in both business and technology. They're well-regarded industry veteran with more than 25 years of domain experience and a proven track record to drive business growth through technology and innovation. So enterprises with the following profiles could benefit from IAPs. So for SMEs and startups, Singapore-based SMEs and startups with at least 30% of local shareholding, it must be willing, able, and ready. So available resource and clear intent for further innovation. Must be technology-centric or technology-enabled company. So specifically for startups, you must be post proof of value, must have a sufficient cash flow of more than 12 months, backed by an institutional investor, and have a capable management team. And of course, all these criteria, they serve as a guideline. Further assessment has been done before any potential projects. So some success stories to share. So like Sinful Tech and Dr. Ong Mei Hong is our innovation advisor. She partnered our local startup Sinful Tech to make their beverage line market ready. So this company, Sinful Tech, they are doing Sakshi production. It's actually an alcoholic beverage made from soy whey. It's a byproduct of tofu manufacturing. But this, well, it's a new product, it doesn't have a conventional brewing process. So with Dr. Ong's advice, Sinful Tech was able to develop this specialized technology. And then it enabled them to scale up this product and offer this product commercially. All right. Another example is CW Aero and Mr. Derek Chappers. So we're now in one of the worst downturns in aviation history. So our innovation advisor, Mr. Derek Chappers, helped CW Aero Services to implement new business strategies and restructure their internal process. His guidance helped CW Aero refocus their priorities and firm out a new strategic plan. So therefore, it helped them emerge stronger during this pandemic. The last example I'm sharing here is between excuse me, FG Foods and Dr. Rebecca Lian. So this company, FG Foods, they want to convert their frozen sauces into shelf-stable products. So they to convert so that you don't need to freeze them, don't need to be in cold chain. And in addition, this will enable to reduce their costly cold chain logistics with their shelf-stable products. All right, so with this development, its R&D team also has acquired new capabilities and know-how of the technology, right, through help from Dr. Rebecca Lian. All right, so in summary, how can IPI support our local startups to grow beyond boundaries? Startups can access our corporates, problem statements, pain points for co-development opportunities via our open innovation challenges that we organize. You can discover collaboration opportunities through our innovation marketplace. via our tech offers or tech needs that will enable you to co-develop or in-license certain technology elements that you require for your product development, or you could use your technologies to help answer to certain technology pain points or tech needs that other companies post. You can reach out to our tech experts to support as well as to augment your internal R&D team. And can also accelerate your growth with guidance from our innovation advisors who are bilingual, experienced in both business as well as technology. So thank you for your attention. That's the end of my presentation. If you have any questions, you can also write to me this email. All right, thanks once again. Marcus, back to you.
Thank you so much, Colin, for this insightful sharing on IPI and your work. So at this juncture, I want to just give a thank you to all three speakers for sharing with us more on intellectual property, and so that we have a better understanding of it. So now we have actually reached the Q&A segment, but I'm also very cautious of the time. So no worries, if any of you have any questions, please feel free to just list them down in our Q&A segment. So we actually, as of now, have a couple of questions. So perhaps with this remaining time, you can just answer one or two of these questions. So one of them, the first question that we have is from Nicole. So Nicole asked on what are the main benefits of registering IP in Singapore, as to say vis-a-vis in the EU or in the US jurisdictions. So I believe this question is more of an overseas, has an overseas element to it. So I was wondering if Kim Tean would like to take this chance to answer this question. Hi, Kim Tean.
Yeah, certainly. Can you hear me?
Yes, yes.
Yeah, okay, good. Yeah. Yeah, hi. Yeah, so I think the question is basically what are the advantages? I think, remember my first few slides, I talk about law being dilatory in nature, including IP registration, which means if you filed in Singapore, but you did not file in USA, meaning that someone can actually infringe and manufacture your product in USA, and there's nothing much you can do about it. Because the American police is going to tell you, but you didn't seek protection in my country. Why would I want to protect you? You didn't pay my US PTO the registration fees. So the question you ought to think about, points that you ought to think about is it costs money. You have to look at where your areas, the territories which will best protect your products. As I said, it's actually a dilemma between two sides. First, of course, protections is as many countries as you wished. And on the other hand, cost constraint, time constraint, resources constraint, right? So my advice to most of my clients, startups or even big MNCs, even big MNCs cannot afford that kind of budget, because you can imagine being a big MNCs, they got more portfolio, more patents or trademark under their portfolio. And likewise, the cost would correspondingly be much higher. So my advice is typically you look at your products, you decide a few considerations you must always bear in mind. One, you have to think about, is your product only protectable in Singapore, or do you need it to go overseas, where your market resides? In today's context, because we use internet to sell our products, so sometimes it can be a bit difficult, but I still have this pointer because, for example, you are doing, let's say, water membrane and water desalination, for example, then probably a country that you want to look at will be more the Middle Eastern countries as opposed to, let's say, Iceland, right? So it's still valid today, although we are using internet as a transaction, but your product, if the market, the product that you sell, predominantly like water desalination is more suitable for Middle Eastern countries, then maybe you want to put Iceland, the Scandinavian countries, good to protect them, but you may want to scale it down and prioritize them accordingly, because of budget constraint. So that is one factor normally I would advise my clients to take note of. Another is, of course, where you assemble. So for example, if you have a laptop, right, and you know that although the laptop is protected in Singapore, and and it's not sold, let's say, in China, or the handphone is not sold in China. But you always bear in mind that a lot of this supply, the parts suppliers are coming from China. Then you may want to protect in China, because although the assembly part is not done in China, but the supplier, the press buttons, the antenna, or the screen, or the LED is all coming from China. So that is a country that probably you want to protect as well. So in terms of strategy, there are enough literature out there. But at the end of the day, you have to consider, as I mentioned, it aligns with your company's overall business strategy, and then making sure that when you file, it will be prioritized in the order of importance based on consideration like where your product resides, whether your product has got customer at the place, and so on and so forth. One difficulty that you probably will face, which I always find difficult to answer, is not so much you know that you're going to need it, but you don't know whether it would happen. Let me just elaborate that very quickly, meaning that you know that, hey, I think my product can be sold in US, right? I think there is a good market there. So you need to protect, because otherwise, as I mentioned in the preamble, you don't protect, you don't get protection, anyone copy, there's nothing much you can do. But the problem that is always an assumption, and it takes a while for it to achieve, for you to materialize, for you to reinforce and testify that your assumptions are right. That would probably take about 12 months to sometimes up to 1.5 years. And this is a very difficult answer, a question to answer. So my advice is typically rely on remember just now I talked about Paris Convention, rely on PCT, which allows you 12 months grace period, 30 months grace period. So this will be helpful when you think about investing further in IP protections in countries far away, and you're not so sure whether the business on paper will take off. Sorry, a very quick speed up answer to that. Right. Thank you.
Thank you, Kim Tean. Thanks for answering this question. I'm mindful that it's already 11:32. So I believe we have now come to the end of the Q&A segment, and as a whole, the webinar. So thank you all participants for attending this webinar. Before leaving, before exiting, I would like to just ask that we do a quick photo taking session. So if you do not mind, we seek your assistance to please turn on your cameras, including our speakers as well, Eric and Colin. If it's okay with everyone, just turn on your cameras for a quick 1 to 2 minutes, so we can just take a group photo, and Jaspinder will assist with taking the photo.
Hi, sorry. Marcus, sorry, do you take a photo, is it? In this
yes, just
okay,
if it's possible.
Sure. Okay, get everybody to just smile. Ready? 1, 2, 3. Okay, can.
All right. Okay, great. So we have now come to the end of the webinar. A big shout out to the speakers and the panelists, and thank you everyone for attending this intellectual property webinar. And if you have any queries, I believe you have the contact emails of Kim Tean, Colin, and Eric. And please feel free to just reach out to us. And with this, thank you all and have a great Wednesday ahead.
Thank you. See you guys. Bye-bye.